Hello, my name is Thorne Barasa, and this is our class on memorial writing. I am the president of the ICJ in gluns, and today I am grateful to take you through what it means to now do written submissions before the court. In our previous class, we concluded by looking into written submissions after applications have been filed and the court has satisfied itself that it has jurisdiction. We then transition into the written submissions, and that is exactly why we're here today. And well, for starters, what is a memorial? And for teaching purposes, we shall call a memorial a legal brief or a written case presented to the court. What does it mean? A memorial is basically the document submitted by each side, either the applicant or the respondent, that is the entire case of the side presented in a written format. That's why I said it's a legal brief or a written case. So it's your entire case, what you're going to say, but in written format. And it is the primary way within which delegates demonstrate their understanding of the law, how you construct legal arguments, and how you persuade judges. So before any oral arguments take place, the memorial establishes the framework of the case. In the context of MUN, the memorials are written way before the oral phase. So for instance, we've already given you a case, you've written your memorials, and then you will transition to the oral phase. But it's the case is tabled, written submissions, and then the case itself. So what is the purpose of a memorial? Because why are we writing an entire case? And the memorial is important for three things. One, it shows that the court has jurisdiction, because in simulations, we won't do the preliminary objections, so to speak. Those will be done within the memorial itself. You don't have to do an application. But it has to state that the court has jurisdiction, and that's always the first issue handled within a memorial, because as I've said, jurisdiction is everything. Second, it has the facts that support the responsible parties' claim, the facts and the law and the analysis of the same. So what are the facts? The facts of a case are basically what happened in the case, the proceedings, the things that led up to the crime being committed, or the thing that is being brought forward before the court. So those are the facts of the case. The law are the rules, the statutes, and everything that you need, and the analysis of the same, and that's how you make a case. So a memorial establishes the court has jurisdiction, lays out the facts, lays out the law, and we apply these two into coming to a conclusion or to come to a requested outcome. And a strong memorial doesn't just state conclusions, it builds a logical argument by linking facts to legal rules that are derived from the ICJ statutes and other sources of international law. And of course, a memorial has structure, and that is what we're going to look at next. And it has a clear and consistent structure. Memorials might vary with the formats, especially in different competitions or different MUN conferences, but these are the essential components which remain the same. First is the title page. The title page contains the court, in this instance the ICJ, the parties, applicant versus respondent, for example, Kenya versus Uganda, Nicaragua versus the United States, and the role of the delegation. So are you the applicant or are you the respondent? So the title page normally needs to have the court, the applicant versus the respondent, and what side is writing the memorial, which is the formal identity of the document, right? And from the title page, then you move forward to the table of contents, because as I've said, it's a structured document, so you need to outline all your arguments within a table of contents, which is just an overview of the memorial, and it helps the judges to navigate and locate arguments if and when they need to read them. Then there's the statement of the facts, which sets out the relevant background to the dispute to tell us the reason why this case is here is because this and this and this happened, in a summary. It's neutral in tone, even if it's written from the perspective of one party. So the applicant doesn't just say their facts, the respondent don't just say their facts or facts that support their case. It's very neutral. And then there's the issues for determination. So you outline to the court, what questions does the court need to answer today? Whether the court has jurisdiction, whether this constitutes a violation of the treaty, whether this party is entitled to pay damages. So the issues for determinations are the legal questions that the court needs to answer. And they need to be framed very clearly, because this is essential so that the court is not confused. And then we have the summary of the arguments, which we are saying in brief. These are the facts, these are the issues, this is what we're going to say. And then now you get into the arguments themselves, the legal arguments, which are the most important section in the memorial, because now this is the case itself. And each argument should employ what I like to call the IRAC formula. IRAC is a mnemonic that is used to frame a legal argument. IRAC means issue, rule, application, and conclusion. So with the IRAC formula, each argument should first identify the legal issue or the question the court needs to answer. Sorry. Secondly, it needs to identify the rules or the law that is applicable to the facts to make the legal argument. Third, which is the analysis, A for analysis, is that you should now merge the law, apply the law to the facts, and make an argument. You've said this section of this treaty provides that no country shall cross another country's borders. In the case, country A did this, and in so doing, they crossed our border. Therefore, as provided in this specific section, this constitutes a violation, and as such, we ask that the court rules on this matter in such and such a way. And that last part I've said, and as such, we provide that the court should do this, is the conclusion, which is essentially what the other side is asking for. So you've come and told the court, this is the issue, this is what the law says on this issue, this is how the law applies in this instance, and this is what we want. That is the structure of the argument. And at the end, there's the prayers for relief. The prayer for relief sets out what the respective state is asking the court to do. It's not a prayer, so to speak, but it is what you're asking the court to do. And this can include declarations that the opposing state has violated international law and request for remedies. And this section must be very precise and linked to the argument itself. So, I mean, you need to have, there's the style and the technique used in memorial writing that is also very important, and it requires clarity, it requires precision, and it requires logical structure. The argument should be presented in a formal tone. There's nothing informal about a memorial, and it should avoid either emotional or political language. As I've said, the court only answers legal questions. The court does not answer emotional questions. The court does not answer political questions. Therefore, as a delegate, you should 1. Write in clear and concise sentences. 2. Use legal terminology correctly, because that's what will give it the formal tone. 3. Support every claim with an authority. Authority are the sources of law. This is why we're saying this. This statute provides for this. This treaty provides for this. In our present case, we can see the application of this treaty where the state has failed to follow it, and as such, we ask the court to find that this and this is the case. And you need to maintain consistency in argumentation. That is, if you've said this is wrong in the beginning, you cannot come and say, or maybe this is right. You need to have a clear legal position, and you need to advance that consistently. And the common mistakes in writing memorials, and this has been seen in many people. First, failing to establish jurisdiction clearly. You cannot assume the court has jurisdiction. You need to establish jurisdiction clearly. Secondly, mixing facts within the arguments. You have a legal argument, but the fact you are using does not apply in that specific instance. And that happens when someone hasn't fully understood their case, which is why once you get your case, you're supposed to read the case, understand the case first before you even start writing. before you even start researching. Making unsupported assertions is another mistake, and by this I mean you make a legal argument without any legal source. It has to come back, either a case, either customary international law, general principles of law, treaties, and all this need to be very clear. Scholarly works as well, because these are how you make a legal argument. These are the basis, this is the foundation of your legal argument. And as I said before, using political or emotional or rhetoric language instead of legal reasoning. A lot of people have a lot to feel about certain matters. That does not make it a legal argument. What makes it a legal argument is how you approach it, and that's why you've said IRAC. Identify the issue, identify the rules or the laws that apply, analyze this by applying the law to the facts, and then the conclusion, which is the other side's claim. So what is the importance of memorials in our context? Memorials are very heavily weighted, especially in the ICJ. Why? Because we like to see your depth of research, and you'd like to see your clarity of thought when you're writing in paper. And it demonstrates a delegate's ability to think like a lawyer and apply international law systematically. Because the issues we'll be handling are not issues that have had direct answers by the court. And so it is up to you as a lawyer, as a delegate, as an agent of the court to think this one out. So a well-prepared memorial strengthens oral arguments. It anticipates opposing arguments, and it provides judges with a clear understanding of the case. You need the judge, if and when they read your memorial, to understand exactly what is going on and to understand your position. And for this reason, you should look at memorials as the backbone of your performance. Many people find it boring, but I find it fun, because you get to research, you get to interact with different sources, you get to question the law as opposed to just say this is how it was said. You look back and you say, okay, when this law was being passed, this is what was going on. This is how it will help my case. These are the special circumstances. These are the exceptions. Therefore, the memorial is your written case. And upon your case being written, we will need to hear from you in court. And that then leads us to the oral arguments, which shall be our next class. So see you in the next one.